Start. The petitioner has specifically stated on oath in paragraph 15 of the writ petition that he had no knowledge of the said FIR or pendency of any criminal case against him, full stop. Further, in para 17 of the writ petition, it has been stated that the petitioner was never arrested in the aforesaid case and he never applied for bail, full stop. The learned counsel for the petitioner has even argued to the extent that the petitioner was never present in the trial and it was on the behest of other persons named in the FIR that the case was contested in the trial court, full stop. As such, when the FIR was not lodged originally, he had no way of knowing about it unless it was investigated, full stop. He was never detained at the police station, never summoned for questioning or arrested for interrogation, there was no way the petitioner could have known about the pendency of a criminal case, full stop. The counsel for the petitioner has further argued that even otherwise the said criminal case has arisen out of a cricket game being played casually in the locality, full stop. A dispute has arisen on the spur of the moment and it was a normal kind of scuffle which cannot be any indication about the character of a person being of criminal nature, full stop. After the game was over, the matter had been forgotten by everyone including the petitioner and he never imagined that an FIR will be lodged in such a small matter, full stop. In any case, there is no evidence on record to prove that he had knowledge about a criminal case being pending against him and the information provided by him in the affidavit was absolutely true to the best of his knowledge and belief, full stop. The learned standing counsel has filed a counter affidavit and has argued that since the information given in the affidavit was belied in the verification, hence the superintendent of police was justified in cancelling the examination, full stop. On careful examination of the counter affidavit, this court could not find any specific averments or material to prove that the petitioner had knowledge of the pendency of the criminal case against him, full stop. A rejoinder affidavit has also been filed reiterating the allegation and stating therein that there was no material before the superintendent of police that the affidavit was deliberately filed in order to conceal some material fact or to mislead the authorities into getting extra marks for the purpose, full stop. This being the case, this court comes to the conclusion that on the date when the affidavit was filed, the petitioner was not knowing that the FIR was lodged against him, full stop. Moreover, on the date when the petitioner was sent for training, he already stood exonerated by the trial court on merits, full stop. The order of the trial court has been annexed by the learned counsel for the petitioner, and the operative portion of the order clearly exonerate the petitioner, including others, of the charges under which the trial has commenced. Full stop. Para. Under the circumstances, the court feels that the affidavit filed by the petitioner was genuine and no attempt was made by the petitioner to mislead the authorities. Full stop. There was no evidence before the Superintendent of Police, Manpuri, on the basis of which he could unequivocally come to the conclusion that the petitioner has filed the said affidavit with malified intention. Full stop. His belief that the petitioner's affidavit was filed deliberately is not based on any cogent material before him, hence the conclusion drawn by him is incorrect. Full stop. Apart from this, the court does not have any material to come to the conclusion that the impugned order has been passed after application of mind. Full stop. Therefore, it is an arbitrary and unreasonable order. Full stop. Accordingly, this court quashes the orders dated 17.12.2007 and directs the opposite parties to immediately reinstate the petitioner on the post where he was working on the date. Full stop. It has been further pointed out by the learned counsel for the petitioner that this court had already passed an interim order on 15.2.2008. Full stop. It is a matter of great concern that this court order has not been complied with. Full stop. The petitioner shall be deemed to be in service since the impugned order was passed. Full stop. Para. Learned single judge further observed that while examining the documents and exhibits produced by the petitioner in the Form 20, there was interpolations. Full stop. The learned judge observed that there is no scope of giving any relief to the election petitioner. Full stop. Moreover, there is direct allegation against petitioner that he along with his persons had made this interpolations. Full stop. The observation made by the learned single judge in para 29 of the order does not cast any reflection on petitioner. Full stop. He did not examine the matter in detail with reference to the original records. Full stop. Though learned judge found that there were some difference in the votes and such difference was an arithmetic error and it does not materially affect the result of election. Full stop. He also observed that Form 20 bears the signatures of the elections petitioner and his counting agents and no such objection was raised. Full stop. Over.